Okay, hi everyone. I hope all of you are doing great. This is another current affair important session. Basically, what happened is our Prime Minister during a recent meeting between the chief ministers and the judges of the Supreme Court, he raised the issue of the people who are not yet convicted, those who are under trials and who are in jail, languishing in jail, I should say actually. So the point is that there's very many people in India who are not yet convicted. They are under trials. They have been picked up by police and cases are going on and on and on, and nothing is coming out of it. So what happened? In today's lecture, in today's small session, actually, we are going to look into the whole issue of what really happening on that front. Everyone knows that there are difficulties with Indian judiciary. A lot is going on actually with Indian judiciary. They always say they are overburdened. People say that justice delayed is justice denied, and that's is what is the most favorite quote about from the sides of the scholars about the Indian judiciary, because it has been considered over the period of time to be inefficient, or not inefficient, at least you can say that it is getting lackluster. Okay, so the whole issues of under trials who is basically creating a human rights issue now. So we'll discuss it, what happened. So Indian Prime Minister, and Indian Prime Minister Narendra Modi talked about almost more than 3.5 lakh under trial prisoners, okay, who are languishing in jails and nothing is coming out of it. Where he was talking about all these things, what was going on. So there was a 39th conference of chief ministers and chief justices. Now, first understand what this conference was. So basically, in 1953, Government of India and the then Chief Justice of India that thought that judges can perform most efficiently in a best way possible only when they are provided all the required support from the administration, and both the center and the state. And let me explain it how. What center can maximally do is they can provide for the money wise, capital wise, they can provide the required monetary support for the running of the courts, both the local level, district level judiciary as well as higher judiciary, that is High Court and Supreme Court. But the main problem comes with if the state government doesn't support. Basically, when you look into Schedule 7, okay, policing is with the state government, okay, and one of the hand of judiciary is basically related with the policing. Unless and until police department is working efficiently, judiciary can't really do its work. So it is very much required that the state governments and the judicial system are on the same page. And how it happens, and to make sure that it continues to happen that way, it is required that the judicial officers, the highest judicial officer of the land, basically the Chief Justice, and rest of the presiding judges and other High Court judges are on the same platform with the chief ministers, with the state bureaucracy. Now, on and on in every state, the chief justices of every High Court, whichever territory wise they are operating, they always keep in touch with the state governments, the chief minister, the chief secretaries of the specific state. But to have an overarching view, okay, it is required that once in a while, there should be a wholesome meeting where everyone can have their say. So this whole thing started in 1953 as a conference where all the stakeholders, whether in the judicial side or in the executive side, who ultimately end up with the responsibility to execute the orders of the judiciary, they can resolve the issues between them. Fine. So this time it was the 39th such meeting between the chief ministers and the highest judicial officer. Not only chief justice was there, but at least the stated fashion is that along with the chief justice, at least 2 more senior most judges of the Supreme Court should be available there. Along with that, the chief ministers are there. Prime Minister also comes to the conference. Okay. Now, About this conference, first of all, understand that last such conference happened in 2016. So basically, it is happening after 6 years, which is a pretty long period. Some can always say that it took so long because of the COVID. Because in COVID, anyway, there were a lot more problems. Even the working of courtrooms was not possible in the standard fashion. They shifted to Zoom and all. So talking about bringing in changes at that moment wasn't possible. So now it is taking place. So in total, from 1953 till now, 39 meetings have taken place. And at this 39th meetings conference, when Prime Minister was talking about what his opinion is, what he wants to say, he highlighted this thing. And this is a very famous argument, because let me show you another image and that will clear what I'm trying to say. Yeah, as you can see, this plot, this bar curve, you'll see that from 2015, 67% of all the people who are in jail were under trial. So basically, 1 in every 3. Okay. Now in 2020, it became 76%, like 3 in every 4. Otherwise, it was 2 in 3. Okay. So basically, the thing is getting more and more dire. Basically, more people are getting arrested than the number of cases getting resolved or sorted out into the courtroom. That's the basic inference one can make. Ultimately, ending up more and more people landing up and languishing in jail. Okay, out of every 4 people who are right now in an Indian prison, 3 are not yet convicted. You must, and everyone must know that Indian judiciary works like this, that unless and until you are proven guilty, you are considered like normal. You will be treated on the footing of any other citizen of India. Okay, you cannot be considered convicted unless and until the decision of the courtroom comes. But still, they are languishing in jail. So why it is happening? What is the reason behind this? Let's discuss this thing. What's the reason behind this happening? So, and this note which I am surfing you through will actually be available on the website of Shubhra Ranjan IAS. Okay, so what I'll provide the link in the in just below this video. You'll find the link of the this particular. It will be available in PDF form, as well as you can read it on the website. So the link will be there, and you can go through it. Okay, through that link. So you can refer to the material also. Now, fine. So what's the reason for this delay? Why it is happening? First of all, Indian judiciary is highly overburdened. Okay, there is a famous quote that there are more than 4 crore pending cases in Indian judicial services right now system. Now, beyond the overburdened judicial system, what else? The policing system, it is also overburdened. Like if you ask the judicial side, they will say that the police is inefficient, but if you ask on a humane side to the police officers, they will tell you that they are not inefficient, they are overburdened, and that's ultimately comes out as inefficiency. So that thing you have to keep in mind. So overburdened judiciary, overburdened police department, and the third one is most of the undertrials come from a disadvantaged social group. Now this is very essential to understand here. Okay, what do you mean by, like, when I'm saying undertrials who come from disadvantaged social groups? Now look, most of the time, although it sounds not that good to say, but the reality is that as a society or even as a family, many a time people look at someone as their economic worth. So suppose there is someone who comes from certain strata of society where economically they are not provided for in the initial phase, and since they are not capable of anything adding into right now in the economic sense, in the immediate monetary sense, they don't have the economic resources to get a proper lawyer to facilitate other things if in case they are get dwelled into any of the specific cases. Now understand this thing, most of the people who are in jail right now, socially and economically, they are, first of all, socially, they are mostly from those caste groupings, those social groupings who are anyway considered from the backward and other backward classes and scheduled classes and scheduled tribes. Okay, so in comparison to, so that thing is also visible there. Now, then other problem is because they belong to such classes, such social section of the society, they are economically not well to do, and so most of the people, even in the case they are literate in the sense of having a 10th standard degree or a 12th standard degree, matriculation degree, but they are not legally aware, or what we should say, legally literate. Okay, the legal literacy, and one should know that the Indian or that every system which is available, basically all the legal system which are based on English legal system, considered a person to be legal literate all the time, no matter, even in the cases when they are actually in all for all purposes they are illiterate also. If you are what we call angutha chap, then also you will be considered a legal literate in a court of law. Okay, but ultimately these people are legally illiterate in most of the cases, even though they have a matriculation degree. So hoping for them or even their own family to come forward, take responsibility, hire court lawyers and go and argue and look into it that what can they do, this is not possible. And many a time these people just land up in jail once and then they just languish there because they don't know what to do. So that's a very big problem. Okay, the disadvantage of us belonging to a certain social group. And for this purpose, this is a very serious problem, because the rest of the problem, the logistical issues, the inadequate number of judges, the not proper function of policing, is something larger issues which state can solve. But this social grouping problem is something because of which in 1980 the Supreme Court also gave a judgment, and as per their ruling they said that Article 21 of the Constitution entitles a prisoner to a fair and speedy trial, and to make sure that their fundamental rights and their liberty should be saved and protected. So Supreme Court in 1980 itself said that it is the responsibility of the state and it is actually the right of a citizen that their trial should be done in the most efficient and speedy manner. Okay, but that doesn't happen, and no one can really do anything much right now because of the logistical issues. So beyond that, the understaffed judiciary compounds the problem further. That's basically understandable. Now I'll tell you one more thing important, which is that, for example, even in criminal procedure code, there are certain things available which can resolve this problem. For example, section 167 of section 167, and I hope you'll make a note of this. These kind of points are something which you directly mention in the mains examination, that you'll fetch further marks, and your overall in the mind of the examiner, your overall impression will be better. For example, the section 167 of the Code of the Criminal Procedure mandates that the judges can extend a detainee's custody for a period of 15 days at a time, not more than that. Now, does it really happen? No, it doesn't happen. Okay. Section 167 says that every person has to be brought in front of a judicial officer after every 15 days, basically after fortnightly, in a fortnightly thing, to further look into the issue that whether he or she should be provided bail, or he should be given, the authorities should be given further chance to detain them after every 15 days. But it never happens, and no one really talks about it, because again, judicial system will say, look, we already have so many cases, our people don't have time. So look on every case after every 15 days. That won't be possible for us. So both the judicial side of the system as well as the bureaucratic side, the executive bureaucratic side, also don't really talk about this whole section. But you need to know that there is a legal, not only legal provision, there is a written minted policy statement in our legal system for this. Just a moment. Fine. So what's the way out of this? Because that's ultimately one needs to do, to have some understanding and have some argument built up that, okay, fine, if we have to resolve the issue, what's the way out? Now, what's the way out? The keeping these whole issues, there should be an under-trial review committee. Okay, what's a under-trial review committee? I hope everyone should be knowing about the National Legal Service Authority. The National Legal Service Authority Act was actually passed in 1987 by the then Congress Rajiv Gandhi government, but ultimately it was made functional only in 1995 in the last days of Narasimha Rao government. And the whole idea here was to help those people about whom I was just talking a few minutes back, that who are socially incapable to represent themselves or present their best representation. For those people, to help those people who are legally illiterate and such kind of people, National Legal Service Authority was made. Okay. Now the plan is, the idea is, which is not yet implemented properly, the under trial review committee has to be formed in every district, and it should consist of the district judge, the DJ, the DM, that is the district magistrate, and the SP, that is the superintendent of police. And they should look on the case by case basis that which of the under trials should be kept in the prison, because outside they can create further chaos, further difficulties, or influence the case, and which are the under trials who should be given bail, because their presence outside the judicial system, outside the jail actually, is not going to influence the case in any way, as well as they are not going to make life for other citizens of the country difficult. If that's possible, one should be given bail. Okay, yeah, that is also required. Let me explain this thing. When one should be given bail? Bail is, by the Supreme Court of India in 2014 case, was declared that bail should be the mandate. Okay, and jail term or keeping inside the jail, imprisonment, should be the anomaly. Now, when one should be given bail? Even when the case is going on, if it's proven or it's ascertained by the court that outside the jail you will not be able to influence the case and in a biased manner of your own, as well as you are not going to create difficulties for the society at large or any other individual in the society. If both the checks are performed and both the checks have been met, then a person should be given bail. Okay. So who should apply these checks is basically this committee, under trial review committee. Now, the Legal Service Authority, what is this? In a various states must play a principal role in inculcating further awareness among people. Now, this is again something very important. Again, the same strata of people who don't have a better understanding, that many a time people are in jail who don't even know what they have done wrong. Okay, so inform them, provide them awareness. Many a time it happens that people land up in jail, they don't have any of their family members outside the jail. Even when they are done with their jail term, they don't know anything and they just are there, just there. So for those people, proper awareness about the legal system as well as what is wrong, what is right, is also needed to be given, and that is basically the job of the Legal Service Authority. Okay. Now, what's the real solution? The real solution, however, does not lie merely in the early release of the prisoner on bail, but ultimately the problem will be resolved only when the whole thing will be expedited. That is, if the whole cases will be resolved in a faster manner, in an efficient manner. Now, how that will be done? Ultimately, for that, judicial system has to be improved. More judges are needed to be recruited. Policing system has to perform in a better manner. Okay, there has to be more investigating officer in the police department. There are more the junior level judicial officers needed to make sure that the logistics are taken care of, and ultimately there are the most and much needed thing is more and more recruitment of the judicial officer on the position of judges. Okay, so that's what is needed. Now let me tell you, okay, if these all things are done, that's great, but till the time these things are not done, what one can do till then? Till then, Supreme Court has given some judgment, some ruling, and based on them, whenever someone goes and applies, okay, fine, there is a precedent, there is a ruling, and based on that, certain support, certain help is provided by the judicial system. So let me tell you what are these. So in May 2021, for example, when the COVID case, during the second wave of COVID, okay, Supreme Court just passed an order because they understood very well that Indian jails are anyway overcrowded, okay, and under the COVID situation, it will be impossible for them to have so many people incarcerated in such small place, and also make sure that they are not affected by COVID. And because once you are in jail, it's the responsibility of the state to provide for you health facility also. So judiciary said, okay, fine. What one needs to do is provide bail for as many people as required or as possible for the period of the COVID. And when those people, most of the people who came out of jail basically did nothing wrong. Okay, they didn't influence their case in a wrong manner. They didn't created any chaos in the nearby society. They didn't impacted or tried to do harm to the other party in their case. So under these circumstances, this whole idea that you can let more and more people who are not yet convicted out of jail, it is not, incarceration shouldn't be the ideal case. Incarceration should be an anomaly, it should be an exception, and bail should be the ideal case scenario when you are taken in front of a judge. Okay, so this was further supported, this whole argument was further strengthened by this action. Now the key observation otherwise also in many other cases which Supreme Court made was, for example, I was just mentioning about the Anish Kumar versus State of Bihar 2014 case. In that case only, the court said that in all the cases where the maximum imprisonment term for conviction is less than 7 years, okay, one should get bail in the most of the cases. Okay, so that's a particular thing which is most of the time used by the lawyers in the courtroom as a precedent to avail bail. But in the cases where there is not enough information, then it creates again difficulty. Now the second thing, again, Criminal Procedure Code, section 436A, this is also something very important. Basically, section 436A of Code of Criminal Procedure talks about that if a under trial person has already served more than half the period which was the punishment for doing the crime he is being under trial for, okay, he deserves to be on bail for the rest of the hearing. Suppose you have done something wrong and the maximum imprisonment for that thing is 14 years and the case has not yet resolved, the case is still going on, and you have already served more than 7 years in the jail, then you deserve to be given bail for the rest of the time the case proceeds. Okay, so that's 436A of Code of Criminal Procedure. Now the final thing, the court suggested that the legislature to consider the idea of placing convicts under house arrest. Okay, there are so many people in jail, languishing in jail, that court even went to the extent of saying that the state legislature, the state assemblies, state by state basis, wherever they find it's possible, they can also say that a particular person who is under trial can also be kept inside his or her own house and could be done with house arrest. This will help the state in 2-3 different fashion. First of all, that whole thing that letting that person out can make him or her influence the whole case or create difficulties security wise for the other party in the case, that will be resolved because that person will be house arrested. Second thing, the overall cost will be reduced on the state because putting someone in jail anyway puts a lot of huge cost for their foods, their lodging, their health facilities and everything on the state. Okay, and the state has to maintain a certain level, although in reality on ground that doesn't happen all the time, but for practical purposes, for at least to understand this thing, state has to incur the cost and that cost can be saved. Okay, and ultimately there will be more space in the jail so that other people who are anyway inside jail, their life will be somewhat better. Okay. Now, again, before ending the session, let me remind you again that in 2016, the overall number of people who were incarcerated were itself 4,33,033 who were not yet convicted. Okay, these were the number of the under trials, and that consisted of 68% of all the people in jail. So basically, what's jail for? Jail is basically, in the theoretical sense, for, in a way, it's a kind of a punishment for people who have done something wrong. But what if two-thirds in 26 as per 2016 figures and 3/4 as per 2022 figures of the jail's population are basically the people who are not yet proven guilty. Okay, that's the problem which our Prime Minister was highlighting, and the reason for him highlighting in on that platform was because both the state bureaucracy, the state executives, as well as the judicial officers were present on the same platform. So this is something what the Prime Minister done by the Prime Minister, which was very much required. And if the judicial officer or if the Supreme Court, as say, takes any specific action in this regard, that will be really helpful in a very large and help a very large section of the society. Okay, so that is all for this class. That is all for this video, and this whole thing I was just telling you, you can actually go and read. There will be a link down this video. You can go through it and you can read the whole text over there. Okay, and thank you for attending the session. Thanks.